Welcome to CivilNet. My guest is Dr. Marco Sassoli of the University of Geneva. Dr. Sassoli, thank you for joining us.
Thank you.
You are also the Director of Public International Law at the University of Geneva, and you are in Armenia to take part in a panel discussion, The Challenges of Humanitarian Access. You are an expert on international humanitarian law, and for me and for our guests, if you could please define the difference between international humanitarian law and international human rights law.
International humanitarian law applies to armed conflict, while human rights law was made for peacetime, but it also applies to armed conflict. Obviously, human rights law is more protective of human beings than humanitarian law, because humanitarian law applies to a situation, armed conflict, which is basically inhumane. So it can only try to obtain a minimum of respect of the human being and of those human beings which are not involved in the conflict during an armed conflict. So it would be preferable that humanitarian law never applies because we don't have armed conflicts, while human rights law applies everywhere, every time.
Sure. How is, as you call it, IHL, International Humanitarian Law, applied in matters of war? If we take any conflict that's taking place, how is it then applied? Are states bound by international humanitarian law today?
Yes, first of all states which are recognized are parties to the Geneva Conventions, and most states also parties to the additional protocols to the Geneva Conventions. And anyway, they are bound by what is called Customary International Law, which is based on the general practice of states, what they consider to be the rules even in war.
Because even war has rules.
Yes, I would even say it's the definition of war, that it is fought against according to rules. This is the difference between an armed conflict and chaos and common criminality. That in an armed conflict there are two sides and it is fought according to some rules, and not simply everyone kills everyone. And I mean, in no armed conflict in the world everyone kills everyone, because you don't kill your comrades, even in an armed conflict, for instance. And you know, in the media you get the impression that it is not respected, because understandably and rightly so, the media report about the violations. But this should not give us the impression that this law is most of the time not respected. Most of the time it is respected. Unfortunately, too often there are violations, and the media are right to speak about these violations. It would be like the Pravda at the time of Stalin if they reported about respect.
This year is also the 150th anniversary of the First Geneva Convention.
Yes.
And we were speaking earlier about the convention, about being in media. We are looking at conflicts in our region in recent years. If we look over the past century, we've had the two major world wars. We understand conventional war between state actors, between states. Again, because we have been reporting extensively about the Islamic State and about non-state actors, which, as you explained earlier, is not a new phenomenon, but it's something that is very, very much a part of our news stream today. How do non-state actors comply with IHL, or how does the Geneva Convention, how do international bodies or international laws apply to organized groups like the IS?
Well, first, in non-international armed conflicts, fewer rules have been accepted by states. Second, don't think that states always comply. Sure. Third, states have a schizophrenic approach, because on the one hand they don't want to speak about non-state armed groups because they hope that they disappear if you don't speak with them, and that everything, including humanitarian rules, could legitimize such groups, and on the other hand, they complain that the groups do not comply with the rules. Now, there is one article in the Geneva Conventions, Article 3 Common, which is explicitly binding both on state and on non-state armed groups. And in addition, it is important, if you want to get the respect of anyone, you have to speak, you have to convince. And so it's important to work on both sides of every conflict, and a lot of armed groups have undertaken. They are not only bound, but they have undertaken to be bound, but they cannot become a party to the conventions, right, because states would never accept. So they are only bound because they declared informally to comply.
Dr. Sassoli, you were talking earlier about engaging with these non-state actors and the importance of that kind of engagement and discourse, because if you're not speaking to one another, if the parties involved in a conflict, if it's a state or a non-state or two non-state or whatever the configuration is, do organizations like the ICRC or other international bodies, should they be compelled to engage with these non-state actors?
Well, I think
that we consider
they
terrorists?
already do it. Simply, they cannot do it too openly because states don't appreciate that. Because now, in most cases, the non-state actors are qualified as terrorists, and so if you speak with terrorists, somehow you support terrorists. But the ICSE informally obviously must have contact with both sides, which is not always understood because people are convinced that their side is right and that the enemy is
You should never negotiate with terrorists.
Yeah, exactly. But on humanitarian matters, this is totally wrong.
I want to.
If the terrorists are an armed group, because, I mean, not every terrorist is an armed group. This was also a mistake of the American approach to the so-called war on terror. But I mean, if it is Islamic State, you cannot say Islamic State are simply some criminals. They control more people than many states. And so you have to engage them.
Okay, I want to talk about the region, if we may. The Armenia-Azerbaijan conflict over the Nagorno-Karabakh conflict. It is a frozen conflict, 20 years now, also marking the 20th anniversary of the ceasefire that was brokered by Russia and Bishkek. 20 years yet, we really can't say that we have peace in the region. We often say it's a condition, a situation of no war, no peace. Now, in terms of international humanitarian law, when peaceful civilians are being targeted by national armies along state borders, how does IHL have a role to play, or are states bound by that law to protect peaceful civilians living on border villages?
To respect. Now, this is a specificity of humanitarian law. Not every civilian who dies is a violation of humanitarian law. But what you say, if they are targeted, this is clearly a violation of humanitarian law. But it may be that civilians die when you target a military objective. Incidentally, because they are around a military objective.
Not that they were necessarily targets, they were just bystanders who happened to be killed. Now, one other question. Again, in the Nagorno-Karabakh conflict, we have the state border between Armenia and Azerbaijan, and we have the line of contact between Nagorno-Karabakh and Azerbaijan. In international law, are those not defined? Are they seen as different conditions? For example, if a border villager is being targeted along the state line, because if there are no other military objectives there to be attacked, and then if they are along the line of contact and being killed.
For humanitarian law, this doesn't make a difference. For international law, obviously, borders make a difference, and the line of contact is not the border.
Right.
But for humanitarian law, wherever the fighting between two states or between a state and a non-state entity, and Nagorno-Karabakh is for the overwhelming majority of the international community a non-state entity. Wherever there's fighting, the rules on humanitarian law apply, independently of whether this is right, wrong, whether they should be there, where the border should be, and so on.
Just as a final question, I want to talk about a publication that is also going to be presented at the panel discussion, How Does Law Protect in War?, which you are a co-author of.
Yes. Well, this was a book, we are already in the 3rd edition, presenting cases from all over the world. Now we have 350 cases, and the book becomes, unfortunately, I would say, there's more and more practice on humanitarian law, so it becomes heavier and heavier. And the idea was to make it available over the internet and to take advantage of the fact that on the internet you can make links between the theory, the rules, cases, the provisions of the Geneva Convention, and so now, and this is launched really this week, and so in Yerevan is the first time that it is launched, there is an internet platform which has also the advantage that you can update. So we have, for instance, if you publish a book, you are always 1 year late, and then you don't publish every year a book, so it's every 5 years that we updated it, while now we have new cases from Syria and so on. So I think, and this is mainly for students, this book and this platform, it makes it easier for teachers to take, because you cannot teach the 350 cases. So teachers will choose according to their interest, the interest of the students, the region, 1, 2, 5, I don't know, my 1 year course is 15 cases. But then they discuss these cases, and I think it's important that students learn that humanitarian law is not like Roman law, a thing about theory, but it is about real human beings who have a real problem, and humanitarian law, if it is respected, gives some solutions to these humanitarian problems, like humanitarian access. The question, when has an outside organization the right to be present?
Well, it's a fascinating conversation, Dr. Sassoli. Thank you so much for coming to help us understand a little bit more about international humanitarian law.
Thank you very much.
I'd like to remind our viewers that my guest was Dr. Marco Sassoli from the University of Geneva. Stay with CivilNet.